Hey folks, Attorney Sharif Silmi. By now, most of you have seen the release of the December 2020 Visa Bulletin. And as we predicted, there is some retrogression with respect to the EB3 category. So what I'd like to do is I want to take you through the EB3, EB2, EB1 categories of the employment-based Visa Bulletin and how it impacts those of you with country chargeability of India. So anyone born in India, I hope you're paying attention. Now, so what we find is that the EB3 category retrogressed by 1 year from January 1st, 2015 to January 1st, 2014. So anyone who has a priority date that is earlier than January 1st, 2014 may still apply within the EB3 category. They received a huge amount of adjustment of status applications in in October and November. Thus, the retrogression has taken place in the EB3 category, and I think that we can anticipate that to continue, although perhaps more modestly in the coming months. Now, those of you in the EB2 category, there has not been any change there. It remains May 15th, 2011, which was an improvement over the previous fiscal year. However, it is not advancing any further. And of course, the EB1 filing date is now current, even for India. So here's my recommendations. Anyone who is in an EB2 situation where your employer has indicated a willingness to downgrade and your date comes before January 1st, 2014, you ought to downgrade. Take advantage of the priority date. Make sure you file within or prior to the end of the year. Therefore, you'll have a pending adjustment of status, I-485. You'll also be applying for employment authorization, I-765, and you'll be applying for advanced parole, I-131. So it is unlikely that this process will result in a green card. It will, however, provide you with a work authorization document and advanced parole, meaning you can travel outside of the United States and return with that combination card of employment authorization document and advanced parole. Now, if you downgrade from EB2 to EB3, you can only have one perm application at a time. Therefore, you will essentially lose your EB2 spot. So if there's more retrogression in the EB3 category and the EB2 category advances, your employer will have to file a new I-140 for you. You cannot have two I-140s and one perm. One perm will only apply to one I-140 at a time. Therefore, what you need to do is, if you are going to downgrade, I strongly recommend you look at a self-petition EB2 National Interest Waiver. Now, a lot of folks out there that I consult with, that I speak to, they always have this objection, which is one of the silliest objections I've ever heard in my life, in that I don't know anyone that has done it, therefore I don't feel like I should do it. That is a recipe for losing and disaster. What you ought to do is fulfill everything that the law allows you to fulfill. I call this the all of the above strategy. You have your life on the line, and you need to make sure that you're putting yourself and your family in a position to be successful. So if you are, for example, a software engineer, and you are working in a software tech company, or let's say you're working as a government contractor for a government contracting organization, and you're doing database migration, for example, and you're creating new databases that the government is going to be using to optimize its information databases, you are fulfilling a role that is, number one, of national importance and substantial merit. You have the experience, the talent, the education. Therefore, you are well positioned to fulfill this endeavor. And in terms of a balance test, you will absolutely be in a good position to qualify for this criteria. Therefore, you are downgrading from EB2 to EB3 to take advantage of the date, filing for the adjustment of status, or you have already done so in the month of October or in this month of November, you plan to do in the month of December, you must absolutely look into whether you qualify for a national interest waiver. Now, to recap, the national interest waiver is available to anyone with a master's degree. If you do not have a master's degree, there is the ability to file under what's called E21 extraordinary ability. Now, the E21 extraordinary ability demands that you meet 3 criteria. Among the criteria include a bachelor's degree. I think everybody in this situation has that bachelor's degree. Also, you may have 10 years of work experience, so that will qualify you automatically. Then you just need one additional criteria. It could be that you command a high salary, that you're a member of professional organizations, that you have reviewed or judged the work of others, that you perform a critical role for an organization that has a distinguished reputation. Any of these categories will get you there. Now, that is what's called the E21 extraordinary ability. That is only in the event that you do not have a master's degree. If you have a master's degree or its equivalent or higher, then you can skip that E21 analysis. Then you only need to prove essentially 3 things. Number 1, that you work in an area of national importance and substantial merit, meaning the area of endeavor that you're involved in is somehow important to U.S. interest. It could be an economic interest. It could be technological interest. It could be a health interest. So if you're, for example, working in healthcare, one that's really, I think, emerging as very popular with national interest waiver is financial technology. So those of you who are in fintech, absolutely area of national importance. Then the second part of the analysis is whether you are well positioned to advance the field of endeavor. Well positioned to advance the field of endeavor. This is, if any of you have ever heard of the EB1A application, it requires what's called sustained acclaim that is recognized in your field of endeavor. So if we compare that very high threshold of sustained acclaim that is recognized in your field of endeavor with what the national interest waiver calls for, which is advancing your field of endeavor, you find that it is a much easier threshold to meet. So essentially, most of you, I would argue, out there that are in a professional class who are doing important work and are advancing themselves throughout this situation will qualify for a national interest waiver. So you downgrade to EB3, file your national interest waiver. Why do you do that? So that you can maintain both the EB3, take advantage of the EB3 dates, which are now far in advance, and also keep your EB2 position, because it is very, very likely that you are not going to get a green card through EB3 anytime soon. And many people are downgrading to that EB3 category, abandoning the EB2 category because you could only have one perm at a time. Then the EB2 will probably advance more aggressively. And you already have a pending I-485 through your employer-sponsored EB3, and you will be in a much, much more advantageous position than anyone who is simply downgrading to EB3 and not taking any further action. At the same time, a national interest waiver is one step toward an EB1A, meaning if you are thinking about the possibility of filing in the first category, EB1A, which is now current, then a national interest waiver will move you toward that direction. So it is a very good idea to enact this all-of-the-above strategy. Now, if you need more information about this, feel free to email us info@Silmi Law, SILMILAW, or call us 443 329-2929, 443-329-2929. Thank you.